Okay, well, good afternoon, everybody. Um, Thank you for joining us this afternoon. I'm Neil Kalin, being joined by Ashley Peterson. We are your co-hosts for What's Up With Us. And today we are interviewing Jonathan Golding, who is the CLA Real Property Law Section Chair, and he has many other accolades besides that. And we'll get to Jonathan's interview a little bit later. We have some other things we want to discuss. We know we had a couple of months off, so hopefully everyone didn't forget about us during our lapsed time. So let's see, what are we going to be talking about today, Ashley? Here's what we're going to be talking about. Why are we even doing this? Well, we want to increase awareness about current real estate legal developments and increase awareness about the real property law section as well. We're going to just start discussing a couple of cases, starting with Southwest Fair Housing versus Maricopa, decided in August of this year. We're going to jump into Pierre versus San Francisco, decided just before that. Then we're going to have our interview with Jonathan, by the way. Jonathan, during our case discussions, hey, anything you want to bring up, feel free to bring it up and join the conversation. We're happy to have you do that. After Jonathan, we're going to talk about Gonzales versus Mathis, a California Supreme Court case. And then a really big issue in real estate, Senate Bill 9, which takes effect January of next year, that allows lot splits and duplexes on single family zone property. You know, the issue is it really the end of single family zoning in California, or is that kind of an exaggeration? Want to remind people about some MCLE and events, and we'll call it an afternoon. So, Ashley, you know, it's been a while. Anything you want to say before we jump into our cases?
No, it's so nice to see you, Neil. I'm so happy we're continuing this for the next real property year. So I'm thrilled to be on board. Thank you.
Yeah, thank you. And thank you, Jonathan, for letting us do this. We appreciate it.
You're welcome. And I thank you for doing it.
Okay, great. So we're going to get started. Southwest Fair Housing versus Maricopa. This is a federal district case at the Ninth Circuit case, federal circuit case, the Ninth Circuit Court of Appeal case. And I thought this was an interesting case because it deals with fair housing issues, but in the context of one government agency versus another government agency. And so kind of a different little twist, whether the principles announced in this case would apply outside of this context. Well, actually, I don't think they're really contingent on the fact that it was one government agency versus another. And I think they probably could apply outside, but let's kind of go through. You've got the full facts, you know, in front of you. I'll kind of highlight those. We've got a municipal water district, and of course it supplies water to residents, and some of these residents, and it happens to be a very small water district. And as with many other jurisdictions, if the tenant does not pay their outstanding balance when the tenant leaves the property, the landlord or the property owner is responsible for making up the tenant's delinquency. And that's something, and again, this is in Maricopa, it's in Arizona, but it's not an unusual situation in California to have that same kind of authorization. In this case, the property owner is actually the county of Maricopa, and it was dealing, and it owned a property that it is renting to basically low income tenants. When those tenants moved out, the county said, we're not going to pay the delinquent bills. So originally, there were some factual issues here, but it sounded like the county originally said, yes, we understand we're responsible, we're going to pay the bills. But when it came time to pay the bills, the county did not pay the bills to the water district. And basically the county said, you know, so what? What are you going to do about it? Because the water districts authority gave them the right to lien property in the event the water bills were not paid. But because the property was owned by a government agency, there was no right to lien the property. The county said, no, we're immune, you cannot lien the property. We may have agreed we're gonna pay, but too bad, there's nothing you could do about it, even if we don't pay. You have no right to lien the property. Good luck collecting, the delinquent amounts from the tenants who are no longer in the property. Okay. So after, sounds like a long time of litigation, the water district decided, we don't like the fact that we're getting stuck with these bills. We seem to be getting stuck with these bills more from this one project that's owned by the county of Maricopa. So we're going to institute a new policy. And the new policy is any tenants in a public housing project, which there happens to be one, this one, owned by the county of Maricopa, well, we're going to charge the residents a $100 refundable security deposit. How did they choose $180 as their security deposit? Well, they did kind of an analysis and they found that the highest amount, delinquent amount that was unpaid was around, I think around $183. So they said, we're going to charge $180 refundable security deposit. If tenants leave, we're going to use that money. Any leftover, of course, will be returned. But for the non-public housing residents, they were only charged a $55 security deposit in order to have their water turned on. So you had these various groups, the tenants, and some groups representing the tenants, like Southwest Fair Housing. Interesting, when I was looking up the official site for this case, and we don't have a full site yet for this case, there were a lot of cases naming Southwest Fair Housing. So I'm guessing they are a very active interest group in the fair housing arena. So they filed a suit. They're saying, well, wait a minute, this security deposit policy violates the Federal Fair Housing Act, right? Why? Because it disproportionately impacts African Americans, Native Americans, and single mothers with children who were the primary, so members of those, one of those three classes or multiple of those three classes, intersectionality, were the primary residents of the public housing complex that was an issue. Well, went to trial. What did the federal district court say? The federal district court said, plaintiffs, you failed to establish that the new policy caused a disproportional effect on the protected classes. The district court said, we're going to dismiss the case. We're going to grant motion for summary judgment. The plaintiffs appealed. The appellate court, and very interesting, the appellate court issued a decision originally, I think I had it actually on that first slide, back in August, but then reheard the case and reissued the opinion, and they just reissued the opinion a few days ago. So it was kind of fortunate that I happened to be checking on this right before we went to printer, right before we went online today. So brand new decision. The other one was gone, superseded by the new opinion. The new opinion, though, wound up with the same result, but for a different reason. And the appellate court said, well, yes, it's true. The plaintiffs did establish a prima facie case that the new policy did have a disparate impact on those identified protected classes. And there's some statistics there showing the difference between the population of the public housing project versus the population at large for the water district customers. And you can see that there is a big difference of the residents versus the overall residences that are subject to the water district's policy. But then the court went on to say, wait a minute, the water district had a legitimate business interest in preventing losses for services that are rendered, right? Unpaid water bills are losses, right? And they are not able to recover those losses, okay, from either the tenant or the landlord. So I said, the general policy may apply across the board, but ordinarily, if you do not have a public entity that's the owner, maybe you could collect from the landlord or the property owner, right? So maybe factually it wouldn't apply, but the policy, oh, wait a minute, is there a legitimate business interest for a policy that has a discriminatory effect or has a discriminatory impact on protected classes? So the appellate court said, well, wait a minute, if there's a legitimate business interest, that's something that can essentially override the fact that there is a disparate impact. There was arguments raised, well, wait a minute, these losses are minor, these are small amounts. The district can make up this money through its reserves. The district can make up this money by charging everybody, a higher security deposit. There's all sorts of other ways. And the court said, it's not really our job to get into the business of, in this case, a water district. That's not our job. The issue was, is there a legitimate business interest in preventing losses? The answer is yes. That has the potential to override a discriminatory impact. And then finally, the court said, water district, you've raised these arguments, but they're not evidence, right? The third step in this process is plaintiff, you have to provide evidence that there are other less restrictive or, less discriminatory relief that is available. So that kind of was a factual issue. There was not factual evidence presented of that. There was legal arguments, but not factual evidence. So I thought it was an interesting issue. Again, really dealing with government entity versus government entity, but we have a lot of areas in California where a utility is allowed to charge a landlord for losses that were left by outgoing tenants. And the issue is, what if you can't recover those? Here we're talking about a policy decision, which is discriminatory impact enough to raise the legal claim? And the court said, no, you need to follow this three-step process. They went through the three-step process. By the way, it's a very well-written opinion for those who are interested in this area of the law. Might be an opinion worth looking at. Ashley, I see you kind of nodding your head up and down and a little bit sideways, so I'm not sure what that means. Why don't you tell us?
Oh, no, this is just taking me back to my constitutional law class back in law school, having to do the rational basis test and the pronged approaches for all the constitutional law issues that relate to discriminatory practices. So it sounds like the court came to the correct decision on this one. And from what I'm remembering from law school, which was quite a while ago now.
And part of this is, hey, maybe next time, we talked about a case, our last meeting that you were in, it was actually a case on signatures and electronic signatures. And part of the issue had to do with whether there was ample evidence presented about whether the electronic signature was actually made or not made. And so it's interesting that this case kind of turned on the same issue, right? Was there ample evidence? Once there was evidence of discriminatory impact, the story doesn't end there. The next step is there a legitimate business interest, right? And then if there is a legitimate interest, you flip back to the plaintiff to show, wait a minute, the plaintiffs have to prove this third step with their evidence, and they just didn't do it. So maybe it means plaintiffs are going to have to be, making better presentations in the future.
Good point.
It seems to beg the question of what evidence would the court have found to be sufficient? Did the plaintiffs fail to bring in expert witnesses who could do a financial analysis for them of, going ahead and raising the security deposit for all the tenants as opposed to the actual rule that had been established? Did they need to bring in economists and talk about, the different demographics? It just makes you wonder, what were they missing?
Yeah, I think that's a really good point, Jonathan. And I did not get from the case what the court thought would be adequate. I think they were able to make their decision without going that far, right? So they just didn't go that far.
Mm-hmm.
Spoken like a true litigator, Jonathan.
What can I say? It's a lesson to to the wary about showing up and having the right evidence at the right time. I suspect a lot of money was spent on this case, and if the court say we're throwing it out because you didn't bring in sufficient evidence, as a litigator, you go, oh, I don't want that mistake. I need to figure out what would have been enough.
Yeah, I agree with you. And I imagine if this is more of a case, brought by a private entity as opposed to, an interest group like Southwest Fair Housing, there may have been some issues between the plaintiffs and their lawyers, but I don't think that's something that would come to fruition with this particular case, given who the plaintiffs and the defendants were.
I mean, it's not unusual that you go to trial and the judge or the jury says, we don't find your evidence sufficient. But it sounds like in this case, there just weren't any factual evidence, witnesses at all practically, and all that was made were arguments, and that seems less than ideal.
Well, of course, this was brought on a summary judgment motion, right? So there was an actual trial, and I'm not a litigator. You could help me out here a lot more, but just because summary judgment was granted, I mean, maybe there's a right to bring the case or refile or something like that. So it might somehow come back. I'm not sure.
It seems unlikely. It seems unlikely if summary judgment is granted against the plaintiff. But I mean, interestingly, summary judgment is brought where there are no material facts in dispute, and the court can rule as a matter of law. But here, there apparently were no material facts presented. If you go by the statement that the evidence just wasn't there.
Right. So, and of course, there was a lot of evidence presented in the summary judgment motion, but not in that third prong, not in that crucial prong of the test that the court relied on. So
Okay.
Good analysis. Well, let's go on to our next case. Pear versus City and County of San Francisco. And I think you're going to take the lead here, Ashley.
Sure. Yeah. So this is also an appellate court case. So the background facts on this one were this couple owned this property in 1951 in San Francisco that had an underground pipeline running through it, and the city and county of San Francisco were granted easement rights, reserving the right to use the surface of the property for a variety of different purposes, including pasturage, access, and streets and paving and things like that, and incidental uses to that effect. There was a auto repair shop that's adjacent to the property that also used the property for ingress and egress to their business as well, and parking cars adjacent to the property as well. So the plaintiffs started using the property for a parking lot, and a dispute arose over whether this parking lot use was actually granted in the deeds for the easements. And in the trial court, they held that basically the parking lot rights were included because 75% of the property was paved, used for access and parking, and that it was part of the uses incidental to what was included in the deed. So that was appealed, obviously, by San Francisco, and at the appellate level, the court did agree to some effect that the deed authorized having use of ornamental landscaping, the 3 existing paved roads, and use of the property to access this Wheelworks auto bays. But they found that the deed did not expressly authorize using the property for parking lot purposes. So they held that the parking lot was not necessary to the enjoyment of the road, and it doesn't represent the occasional or temporary parking that normally accompanies the access in and out of the property. So the appellate court reversed that decision of the trial court and remanded with instructions to enter a new judgment quieting title for the plaintiff's use of the property going forward, and also that they had to provide updated insurance as well, which was kind of a little aside at the end of their decision there. So parking lot use was not expressly granted under the easement deed language.
So actually, I have a question for you, and I don't know if this was, in the facts of the case or not. When I started reading this case, and I didn't go all the way through it, so that's why I'm asking you the question. So you've got a road. I'm thinking, originally I was thinking, oh, maybe the use of the property was interfering with the city and county's, easement. Maybe it made it difficult for them to access the underground pipeline. But if you have a paved road, what difference does it make if it's a paved road or if it's paved parking lot? So that would be the same. The difficulty for the city and county would be just the same, whether it was used for a parking lot or whether it was used for a road. Do you know what was the impetus behind the lawsuit here?
They were talking a lot about the fact that the parking could be long-term, and like even though the paved road was there, it could be removed and they could still access the pipelines. But if there were cars on top of it, really it all came down to what the express language in the easement grant allowed for. And they were basically saying the parking was not one of those things. So I don't think it necessarily mattered what they didn't really discuss what the parking issue was really, but it all came down to whether the deed expressly allowed for parking use or not. And the appellate court said it didn't.
It just seemed kind of, I understand the legal principle. I was trying to figure out, why did this all start? I mean, why did the city care that there was a parking lot as opposed to a road? I couldn't figure that out, and maybe there just wasn't enough in the body of the opinion to figure that out as well.
There wasn't, but my guess would be that it's because the plaintiffs were charging money for parking, and San Francisco is a very lucrative place for parking lots. So that's my guess.
Okay.
I always ask in these cases, what is the court thinking? What policy is the court implementing? Again, being a litigator, I'm focused on how do I give the court what it wants to fulfill its policy. And it seems to me that what the court may be saying here behind the scenes is, we don't want people to come to us with these expansive implied meanings of express easements. If you want to use an easement for something, just put the language in the easement and don't come back and tell us it's more than it says. We're not going to imply that a road or a street necessarily includes parking. If you want to park, put your parking in there.
Yeah, exactly, Jonathan.
And that makes sense. It's to keep the courts out of the problem of deciding what's an incidental use, right? It's there or it's not there, and parking is not some kind of minor incidental use that would be something that would be more significant, that could have impacts on other parties with the same issue.
Yeah, they had a lot of discussion about implied easements versus express easements and things like that. So I think you're correct, Jonathan, in that assessment.
I think sometimes the courts would like to be able to reduce their own burden. If I can be maybe a little judicious about their own use of their resources, and opinions like this might make lawyers and clients think twice about investing in cases where they're seeking expansive implied interpretations of express easements, and may reduce the number of these kinds of cases that get filed.
Mm-hmm. Actually, Neil, thinking back to your question, I do remember reading something now in the case. I think they were going to have a target being developed on the adjacent property, and so that's why this parking issue came up. Now that I'm remembering that, so that's where this stemmed from.
Well, so it goes what you said. Somebody's really making extra use out of what the original grant was for, and you could see, where what Jonathan was talking about, thinking, oh, wait a minute, if you wanted to have that, you should have paid for that if you wanted to have that extra right. So,
right.
Great comment, and it's a perfect lead-in, because now we're going to have our interview with you, Jonathan. You've been already such a great guest, and now we're going to find out other great things about you. So let's hear it, Jonathan and Ashley. What are we going to learn?
Jonathan, we're so excited to have you here today. Thank you for joining us and for all your input on our case reviews. So why don't you give our viewers a little bit of information about yourself and your law practice, just to give you a little intro.
Sure, and thank you for having me today. So I've been practicing law for about 30 years. I've been a litigator the whole time. I love litigation. That's what I live for in my business world, is the challenge of finding the answers and trying to be right for the clients. I do mostly real estate and construction litigation. I love construction litigation because it's very forensic. I get to work with a lot of experts. I get to learn new things about construction all the time. And real estate litigation, first because I had a great real estate professor in law school who made it very interesting. And secondly, because of the historical association of real estate law back to, English law, land law. So that's pretty much what I do.
Nice. And your practice is in Los Angeles, right?
Yes, we're in Los Angeles. We practice statewide, but the bulk of our cases are in Southern California.
Did you grow up in LA, or how did you end up in LA?
I did. I grew up in LA. I was born in Berkeley. My father was at Bolt Hall at the time, although I guess you can't call it that anymore. When he graduated, when I was a year and a half old, we moved back to LA. I went to UCLA and Loyola Law School, and I've never lived any place but LA except my first 18 months of life.
Nice. So what made you decide you wanted to be a lawyer?
I think it's just always been the right thing for me. My dad's a lawyer, so I was raised in and around lawyers. And in college at UCLA, I was a philosophy major, and I really got interested in the logic and the analysis of philosophy, which is very similar to legal analysis, and I think really gave me a leg up in law school.
That's awesome. I really hated philosophy classes, so props to you on that. So for those that don't know, Jonathan is our new chair for our real property law section for this next year. So congratulations, Jonathan, on that.
Thank you. It's an honor, actually, to be in that position.
And I'm so excited to have you. I just know it's going to be such a great year. And you've been on the real property law section for is it 3 years or 4 years now?
This would be my fourth year, I believe.
Fourth year.
And although time's gone so fast, it's kind of hard to keep track.
I know.
Time flies when you're having fun.
Were you the same incoming class as me, or were you a year after me? I can't remember.
It was a year after you, actually. Yeah. You were already there. Actually, when I started, it was right at the transition where Neil became the chair, Neil and Tom.
Okay, right.
Neil. So what made you decide you wanted to take on this hefty burden of being chair for the real property law section?
Well, I felt I had both the opportunity now in my own law firm to be able to give back something in terms of time and energy, which this job takes, as both you and Neil well know. It takes a lot of your time. And we have a firm now with other people in it that we've built over the last 6 years that can help me out. So some of the time burden I can put off on some other people as well, which frees me up a little. But also, the last 19 months has been really a difficult time, not only for the members of the RPLS, but for lawyers and almost everybody just in general. And, this being involved in leadership during this time period has really given me the opportunity to think about, how we can give back to the members of the RPLS, how we can provide not only education, but community to those members who maybe haven't had much of an opportunity for community over the last 19 months. And the sort of honor of working with people, who are like you and Neil, who are really dedicated, great members of our team to come out of this and to be able to move forward, hopefully having live live meetings and, as I say, providing community.
Absolutely. Yeah. So what are some of your goals for trying to accomplish for this next year for the section?
Well, I was fortunate, Ashley, that you and Tara already had a live event. So I don't have to say we will have live events soon. We already have live events, thanks to you guys and your great event down in San Diego a couple of weeks ago. But we want to start transitioning back to live meetings for the executive committee and advisors of the RPLS. We want to start transitioning into occasional live events, which can be held safely, and members of the RPLS and other people who are able to attend those events don't have to worry about, whether those events are being properly monitored, following, the best medical opinions on how to do these things. So I think this will be a very transitional year in a sense.
Yeah. Yeah. And the event that Jonathan was talking about, for those that don't know, was our Funky Fall Soiree we held in San Diego. And Jonathan was kind enough to drive all the way down from LA to come and be at that event. So we had a great time. We had probably like 75 people show up over the course of the night, and good food and drinks and live music. And we were really thankful for our sponsors for that event. So
It was an incredible success. So thank you to you and Tara for organizing it, spending all the time and energy on it. And it was mostly an outdoor event, which was nice. In San Diego, the weather was wonderful, and everybody was having a really good time. And there's such a demand that I'm seeing for people to find a way to get back together in person.
yeah, definitely. I know. And that's what was kind of itching Tara and I to do this event, because we just, it was just, we wanted to see people again, and people we hadn't seen in over a year and a half. So it was great to just catch up with everybody and just have a relaxing evening out. So yeah, great.
Yeah, I know it was worth my 2-hour drive to get down there for it. And 2-hour drive back. It was a really successful event and a great time.
Yeah, thanks. So are there any other events that are going to be coming up, like any of the signature events for real property section for this next year that our listeners would want to know about?
Yes, a lot of it is still in the planning stage. As you might imagine, there wasn't a lot of planning of live events until recently, not knowing what the virus was going to, in a sense, allow us to do. But one thing that I'm really happy about is the focus, Ashley, that you and JR and Elizabeth have been on with regard to healthfulness and mindfulness, and the importance in law of taking care of yourself and having outlets for your stress and anxieties that that lawyers have a tendency to go through. And the idea that you guys had, which I know is still sort of in an early stage, and so I'm not promoting it yet, but the idea of perhaps having a spring conference this year that is combined with wellness. It just seems like such a great idea and such a good time for it.
Yeah, we, as a little preview and teaser for everybody, it'll be in Lake Tahoe and probably in April. So we're solidifying the dates, and once we get that, we'll make sure to let everybody know, because it'll be really fun and you definitely won't want to miss that event. So
there you go. There's the promotion. All right, excellent.
So switching gears.
Jonathan, you've already discovered, being a chair, that it takes time. And one of the things that takes time is you want to support the activities of your members, right? So one of the activities that Ashley and Tara just put on was the funky, fall soiree. I know when I was chair, I was a co-chair with another person, Tom Lombardi, and we tried to go to every single event that our committee was responsible for putting on. But we had the benefit of being able to split up the time between us, right? Because we had two of you. We had two of us. There's only one of you. So I hope you're able to go to, everything that's put on, with the understanding this year there's probably not going to be as many as there have been in years past.
Right, and of course, we've got a great team. Our vice chair, Sean Dillon, is a really dedicated lawyer and hard worker. And I'm sure if there are events I can't attend, that he probably can attend them in good grace in my stead.
Do you have any other sagely advice for him, Neil?
You know what? The best advice I could give is when we actually have our, and now we're having like practically monthly meetings, kind of just sort of let things roll off your skin. don't let things bother you too much. Certain people get passionate about some things and you say to yourself, how can they be so passionate about that issue? I thought this was going to be like a 5-minute discussion on our agenda, and it's blown up into a half an hour, and you just don't understand. It's like, all right, let people have their say. If somebody's that passionate about it, let
Well,
it
actually,
say. Don't get too worked up over it.
As a former president of the Santa Monica Bar Association, I was somewhat battle tested before I arrived. So I've been through that before, and I think there's a real value in managing meetings to try to give people confidence that they'll start and end on time, and that time is being managed during the meeting, and that's something I really want to focus on, is having meetings that are within the time period set and keep the conversation, which is great, moving, but also making sure that it's efficiently managed.
Yeah, definitely. All right, and then the last question I'll leave you with. So you got to tell us something fun about you that we wouldn't normally guess, Jonathan, something secret.
I'm a motorcycle rider. People don't believe it when I tell them initially. I'm buttoned up and dressed for court, but I've been riding motorcycles since I was 18. I had my wild years of riding in canyons on racing bikes, although I was never very good at it, frankly, and always a little bit nervous about those corners where you can't see who's coming the other way. But now I ride big Harley hogs, and my wife and I oftentimes will go on tours, motorcycle touring to other parts of the state or even other states when we have the time. And we just really enjoy being on the road on two wheels.
That's so cool. Now I'm sad I don't have a picture of you on a motorcycle for our slide.
We'll work on that. That's right.
We're gonna let our viewers see that for our next What's Up. We're gonna get a picture of Jonathan.
I will get you.
I've got a question for you. So do you and your spouse each have your own motorcycle, or when you ride, are you riding together on one?
No, my wife Ray, she prefers being on the back. She prefers the great views and not worrying about the road so much. She leaves that to me.
That's
all right.
So we're two up.
Well, thank you so much, Jonathan. You're welcome to stick around for the rest of our presentation, or you can take off if you've got a million things to do, which I'm sure you do. So.
Okay, I appreciate it. Thanks for having me.
All right, thanks, Jonathan. We appreciate it. So let's go on. We're going to go on to our next case, a California case. California Supreme Court case decided a little bit earlier this year, and it's a case, and you may look at the picture and say, we're making light of it. It's one of these cases which is a really tough case because the injuries are really horrific. And when you're working, the reason I happen to know a little bit more about this case is I wrote an amicus brief on this case for the California Association of Realtors. We were not, plaintiff or defendant, just an amicus. And so we'll go through and I'll tell you a little bit more about it. So here's what happened. Homeowner hired Gonzales to clean a skylight over the pool. Gonzales had been doing this for multiple years for the same owner. Recently, Gonzales formed his own company, a corporation. He worked for the corporation as an employee, but he did not carry workers' compensation covering himself in the event of an injury. The skylight was over an indoor pool, so it was not like this little, kitchen skylight. It's a big, big skylight. Employees were up there, were performing work. They're cleaning the skylight. The housekeeper said, there's leakage coming into the house. Go tell your workers to be more careful. So Gonzales went up onto the roof, tell the workers to be more careful. Lo and behold, he fell off the roof. He fell off the roof and he was severely injured. He did not just break a leg, he was severely injured. So afterwards, Gonzales sued the homeowner, claiming that the roof's dangerous condition was known to the homeowner and that there were no reasonable safety precautions that could have been taken to prevent the injury. Therefore, the homeowner should be liable. The trial court looked at the case law and said, well, yeah, that the homeowner is right, granted summary judgment for the homeowner. The appellate court reversed, and then the case was appealed to the California Supreme Court. And the decision is kind of laid out there, already existing in case law. There's this general rule, there's the presumption that the hirer of an independent contractor delegates to the contractor all responsibility for workplace safety. What's the rationale? Who's in a better position to know? The person who's the expert in performing the services, right? Another rationale is the independent contractor has the ability to get workers' compensation, right? And the person who's doing the hiring generally relies, on the contractor and relies on their expertise. And if the contractor thinks that they're going to need additional costs to take additional precautions, then that's something that they will just have to build into their charge for providing the service. There are two exceptions to that general rule called the Privet Rule. That's if the hirer retains control over the property and the hirer's negligence affirmatively contributes to the worker. Well, that's not something that really happened here. The homeowner was not maintaining control over the roof or over the skylight, right? So they really didn't do anything negligent, right? And the second exception is if the hirer fails to reveal a concealed hazard. Well, of course, that exception makes a lot of sense, right? Here the argument was, well, homeowner, you knew this was an old roof. The old roof was slippery, just because you knew that, you should have liability. Well, of course, if the homeowner knew it, the independent contractor expert should have known that just as well, right? And should have taken that into consideration. And it's interesting, the other workers, neither of them were injured that were working on the skylight. It was the head of the company who was an employee of the company is the one who was injured and the one who had been doing this, for over a decade. Mm-hmm. So the Supreme Court basically said, we don't want to expand the rules of liability in this case. The reasons for the Privet Rule still maintain. There's no reason to go outside of those rules and to create an additional exception. And furthermore, if you take what the plaintiff was saying, that it was a known condition and that there's nothing that could have been done to prevent the dangerous condition, then every single case is going to be a factual issue of could something be done or could something not be done? And the court liked the fact that this rule has been in place for a long time and that you can actually have cases decided on summary judgment one way or the other. But if you added that rule about whether there are reasonable safety precautions, then every single case is going to have to go to trial because every single case will rest on a factual determination. Mm-hmm. And the reason I was bringing it up and saying CR was involved because we wrote a brief on behalf of the homeowner in this case. And the people I work for, California Association of Realtors, generally defends private property rights and individual owners. And it's always a tough position when you're writing a brief and the opposing party is somebody who's been horrifically injured, right? You feel terrible, right? But you're trying to argue just a pure policy decision and kind of take them out of the scope of what happened in the individual case. Just at the bottom of the screen, you'll see there's a related case also decided, I think maybe it was 2 months later, called Sandoval versus Qualcomm, which was a similar issue. And the court had to decide whether that Privet Rule should be expanded. In that case, it was a commercial property that was involved. the injury was just terrible. There was working on an electrical system. There was an arc flash that hit one of the workers. He was electrified. It was actually absolutely horrendous. But the court said, no, the same rule applies. We have a rule. The rule's been in place for a long time. We don't want to expand the rule just for that unique circumstance. So either of you, do you got a comment on the case? Do you think it came out the right way, the wrong way? What do you think?
Well, I like to say, Neil, that bad cases make bad law, but this isn't one of those instances. In this instance, you were on the right side of this case, and the court came to the right conclusion, in my view at least, because you hit the nail on the head. It's a policy case. And what are the policies? The policies are who's in the best interest, who's in the best position to protect, and who's in the best position to ensure and spread that risk of injury out. And that would be the contractor who is able to get workers' compensation insurance and spread that risk of injury when things like this happens. And if the court were to rule the other way, the court would essentially be turning homeowners into involuntary workers' comp insurers, and the court doesn't want to do that.
Mhm. Well said, Jonathan.
Very good. Thank you, Jonathan. Great comments. All right, so let's end our substantive section. And we're going to talk about Senate Bill 9. And I put the government code sections up on there for you. And, just could spend a whole hour on SB 9. So I just wanted to give everybody, some of the basics. A lot of people may have heard about it, but not quite sure exactly what it is. So here's what it says. A city or county must ministerially approve without discretionary review or hearing in a single family zone, either a housing development of no more than 2 units, so basically turning a single family home into a duplex, or the subdivision of a parcel into 2 approximately equal parcels, provided that, and here's something that's a little bit vague, provided the applicant, so what does the applicant mean? Does that mean it has to be just a single applicant, or can it be, what if there's partners, what if there's multiple applicants? Not clear, but provided the applicant will occupy one of the units for the next 3 years. So you can take a single family residence, split it into 2 different lots. Actually, then in association with this law, you can take each of those lots and have 2 units on each of those lots. Okay, but you're only allowed to do that lot split if the owner says, I'm gonna stay in the property for 3 years. And I'll get into why we think the legislature, made that limitation on the lot split. So are there exceptions to the rule? Yeah, non-urbanized area, farmland, historical properties, landmark properties. And an interesting one, if the tenant has occupied the property in the last 3 years, or if the property is rent controlled or deed restricted for affordable rentals, okay? If the improvement will be demolished or altered. Wow, well then this rule of ministerial approval does not apply. I'm going to talk about that in a minute too. What are some conditions that a city or county can impose if somebody wants to create a duplex or a lot split? Well, they might be able to impose some off-street parking, off-street, and really an off-property parking requirement. No, excuse me, an off-street parking requirement. But similar to the ADUs that were passed a year ago, the parking requirement would not apply if you're basically close to public transportation. There can be side and rear setbacks, but there's nothing in there about a front setback, kind of interesting. Okay. And if there's a property that is already is closer than this allowable setbacks, that those can remain. No short-term rentals allowed for these kinds of properties. Anything that's approved, either a duplex or a lot split. No short-term rentals, right? Everything has to be at least 30 days or longer. And then there's certain conditions for square footage. If there's a lot split, I said it has to be roughly equal. So the smaller one could be no smaller than 40% of the original lot. Both lots have to be at least 1,200 square feet. And again, we already talked about the applicant has to agree that they're going to stay there for at least 3 years. So why do we think the applicant rule is in there? Well, like everything that goes through the legislature, there's trade-offs, right? And property owners, I think, are concerned that our single-family owner-occupied neighborhood is going to be turned into this vast wasteland of rentals. But if the owner has to stay there for 3 years, the thinking was, I am venturing, that if the owner's there, the owner is going to care about what's going on with the other units that are probably going to be turned into rentals. And so that person will care more about, maintaining the neighborhood and keeping a neighborhood in good condition. For those who are concerned about, again, turning single family residential properties into multi-unit zone properties. And the interesting one about the tenants is, I think the legislature was concerned that tenant properties, the tenants would be displaced by owners who wanted to turn a single family unit into a duplex, or up to 4 units actually, if they do a lot split, if they had enough room to do a lot split in 2 on each. I think the legislature is concerned, we don't want tenant displacement here. And the whole purpose of this law was to permit additional housing, because I think everybody knows in California, we have a real housing crisis. And if we can get more housing units created, that might help alleviate some of those problems. The last item there, currently in California, if you have a home, there's also ministerial right to add an ADU, an accessory dwelling unit, and what's called a junior ADU, which is another unit that is basically attached to the primary unit. So basically, right now, you can turn 1 unit into 3 under the ADU laws. And there was concern that, wait a minute, if you could split your lot, put 2 units on each, that's 4. And if you can turn each of those units into 3, that's 12, right? So you could turn a single family into 12 units. But no, this law says you cannot use both the ADU laws and this current law. You've got to choose which one you want to use. So really, it should amount to, at most 1 into 4 rather than 1 into 12. And that's all I have to say. If you guys want to comment on it, and then we'll get to our last few remarks.
Is this already in effect, Neil?
It'll be in effect starting January.
Starting January. I don't know how they're going to prohibit short-term rentals completely on it. I mean, I understand maybe in the approval process, but how do they prohibit that going forward, I wonder?
Well, but written into the law, it says as part of the ministerial approval, you must prohibit.
But how would you, I mean, I wonder
if somebody does do a short-term, so let's say I split my unit and I said, hey, this is going to be a great, area, I'm going to do short-term rentals.
Mm-hmm.
Well, I would be violating the law that permitted me to do that lot split. So I don't know if the city could come down and then retract that use, or whether a neighbor could bring a claim for a violation of the law.
I'm trying to think of how owners would be put on notice for that.
Oh, well, they still have to apply for approval, but the city has to approve under these conditions. Part of the approval process is there shall be no short-term rentals. So the owner will be getting approval. That will be part of the approval. So the owner should be put on. I can't see how an owner would not be on notice. If an owner is doing this without seeking approval, then they're violating the law anyway.
Neil, I have a sort of a general question relating back to your other occupation, which is, with regard to real estate brokers and agents, which is, do your members think that this law will increase property values because of the new development opportunities?
I have not seen anything coming from my organization that has talked about property values. Now, CAR did support this bill, but the reason CAR supported this bill is that it would increase housing, right? And not necessarily increase housing for owners. So it may not increase the number of people who would be buying and selling, but it would increase housing. So CAR is not just about brokering homes. We're also about representing private property rights, as I say. And CAR is a big proponent of housing and approaches it in many ways. And one way that CAR approached that was to back or support this bill as it was going through the legislature. So I wish I could see some information about, I wish I saw information about whether we thought it would increase values, but I haven't seen anything on that in that light. Great question, Jonathan. All right, we got a few minutes. So, hey, Ashley, why don't we just quickly talk? Here, we put up on your screen, we got some really good webinars that are coming up. You notice 2 of them deal with global commercial leasing issues. So that's Joanne is doing those, right? Yeah.
Yep.
So really great speaker. If you're interested in, leasing outside of the United States, look at those 2 things. Quickly, you can get past webinars. Hey, we have here, look who we have there, Ashley. We got you, we have Jonathan attending the Funky Fall Soiree. Much more festive than the one I went to, which had a Hawaiian theme, and I think everybody got one of those leis. But this looks like a lot more fun, a lot more interaction, a lot more variety of the people who are attending.
Yeah.
Nice go, Ashley.
So let's see. So also, you already mentioned that we hope to have coming up. You said hopefully in April, the wellness retreat. And Jonathan, Ashley, is it just wellness, or is there going to be some educational aspect to that as well?
I have no. I'm sorry. Go ahead, Ashley. You're the appropriate person to answer this.
There will be some CLE components to it, so you will get a win-win.
Okay. All right. Sounds great. And just kind of lastly, if anybody has ideas, you want to do a webinar for real property law section, great, contact Nancy. And we have a monthly, I'm sure if you're watching this, you probably are aware of our monthly e-publication, the monthly e-news, and you can contact Kyle for that.
That just went out today. I just saw it in my inbox. So.
Oh, it did. Okay, great. I didn't see it. Okay, wonderful. You know what? I think mine are getting blocked. We just put in a new system where I work. I got to make sure that's unblocked. Okay, thank you. And then, just 2 minutes left. If you have any comments or suggestions for us, I didn't put down where to send the comments or suggestions. How nice. But I'll just give my email address. You can always send them to me. It's real simple email address, neilk@car.org. That's NEILK@car.org. And you know what? Our past What's Up With Us, they're on YouTube at the CLA YouTube channel. I was kind of looking through it. It was kind of interesting to see what we had talked about in the past. So if you want to hear about what's been going on recently. And actually, I don't think you could join us on December 15th, but I'm going to try and hold the boat on my own next month, see what I could come up with.
You're a champ, Neil. Sorry I can't join you next month. I'll be traveling, but hope everyone has a wonderful Thanksgiving, and thank you so much for all your help.
And next year we'll hear all about your travels. That will be part of the What's
I'll have some good photos.
January. Well, thank you, Jonathan. Again, thank you, Ashley. I hope everyone, as Ashley just said, has a wonderful Thanksgiving and a wonderful rest of the year. Bye, everybody.